When Nero the police dog pawed the door of a car that had been stopped after the driver abruptly swerved across 3 lanes, trouble for Nero the police dog ensued. According to all accounts, the Belgian Malinois did his job when he discovered a pill bottle and a plastic bag containing meth residue. These items served as evidence, enabling police in Idaho to get a warrant and accuse the driver, Kirby Dorff, of felony drug possession. However, when Nero sprang up to have a better smell, he put his paws on the driver's side door, which sparked a constitutional dispute that has now reached the Supreme Court. Whether the dog's simple touching of the automobile violated the Fourth Amendment's ban on unreasonable searches. In March, Idaho's highest court came to the conclusion that Nero's enthusiasm constituted to an unwarranted search and overturned Dorff's conviction. The case is one of many that have been brought before the Supreme Court this year to examine the authority of law officers when they approach vehicles in accordance with the Fourth Amendment. In another instance, the car door was left open when an officer discovered a joint under the driver's seat. A third contests San Diego's policy of marking tires with chalk to enforce parking laws. The Fourth Amendment was broken by Miami-Dade police in 2013, according to the Supreme Court, when they took a police dog past a man's house who was allegedly growing marijuana. In a different decision the same year, the majority decided that it was acceptable for a Florida police officer to search a truck with a drug-sniffing dog during a normal traffic stop. Justice Antonin Scalia, one of the Supreme Court's most fervent Fourth Amendment supporters, died in 2016 and was one of the 4 justices involved in those cases who have since left the bench. Without Scalia, I don't know where the court would come out on those cases, said Michigan State University law professor Catherine Grosso. But these cases are crucial for helping us comprehend the limits of the Fourth Amendment's regulation of police investigation. Pursuing the smell into court without stopping. On a July night in Idaho in 2019, the traffic stop by Mountain Home Police seemed routine. According to court documents, an officer observed Dorff make an improper turn and cross 3 lanes of traffic. Shortly after the police stopped, Nero arrived. The dog's handler twice circled the car with the dog. Nero repeatedly jumped up during the second pass, and at one point he put his paws on the driver's side door and window, according to body camera footage. Due to Nero, police discovered meth evidence in the automobile. They then acquired a warrant for Dorff's hotel room and discovered further drugs there. Canine dogs will occasionally support themselves when pursuing a scent by standing on their hind legs and placing their front paws on a car, according to Don Slavic, Executive Director of the United States Police Canine Association. Because of their extraordinary capacity to trace a learned odor to its source, dogs are utilized to detect scents, according to Slavic. The dog will follow the scent to the source or go as near to it as possible after it recognizes the conditioned odor. Idaho's Supreme Court, however, decided on a 3-2 vote that there was a significant distinction between a dog smelling the air around a car and touching it as it attempted to sniff inside. According to the court, there is a distinction between brushing up against someone else's pocketbook and putting your hands on their property without permission. The court stated, "It is also the difference between a dog's tail that brushes against your vehicle's bumper as it walks by and a dog that approaches your vehicle to jump on its roof, sit on its hood, or stand on its window or door without your permission or privilege." This fall, the Supreme Court will probably decide whether to take the case on appeal. How to challenge your parking fine in Supreme Court. There are battles with the City Council, and then there are battles with the City Council that reach the Supreme Court. That is just what 2 Californian guys are doing in response to San Diego, California, parking ticket violations. The plaintiffs contend that the Fourth Amendment's prohibition against unreasonable searches is violated by the city's long-standing practice of chalking tires to determine if a car has moved. The U.S. Court of Appeals for the Ninth Circuit, which has its headquarters in San Francisco, rejected the argument in October, concluding that the practice falls under the so-called administrative exemption, which permits some types of warrantless searches for highly regulated activities, such as city inspectors who can look for violations of the housing code without a warrant. However, in Cincinnati, a different appeals court concluded in 2021 that the exemption does not extend to tire chalking.